So we're going to get started. We have a jam-packed itinerary, and we know everyone needs to be somewhere else soon. So I'm Gary Feldman. Welcome to our annual employment law update. I've lost track of how many of these we've done. I knew Tamsin would know, our statistician, so this is our sixth. So on behalf of myself, Tamsin Kaplan, Larry Casey, Robert Cates, welcome. We'll be going through a number of topics this morning, and we'll take questions and answers at the end. The four of us will all be here, so if anyone wants to stick around and further discuss any of the topics or anything else relating to employment law, we'll be happy to be here. Big thanks to our marketing team of Joanne and Victoria for really pulling this all together and doing all the work. So I'm leading off with the Pay Equity Act, the act to establish pay equity. Circle July 1, 2018 on your calendars, because this is when this act becomes effective. I'm going to do a brief run through. We could really spend a couple of hours talking about this act, so in my allotted time I'll just going to walk you through that and go over the salient points for employers here. This act was signed into law passed last year. The Massachusetts legislature is also known as the Full Employment Commission for Employment Lawyers in the state. They keep churning out many employment law, many leave laws, and equity laws. So here, let's walk through this. This is a Massachusetts statute. So we have already on the books, we have the Federal Equal Pay Act. We have the Massachusetts Equal Pay Act, which this is really superseding. It becomes effective July 1, 2018, as I said. That may seem far away, but there's a lot that employers could and should be doing between now and July 1, 2018 to get yourselves in compliance and to present yourself with a defense to any claims, and I will get into that. It applies to all Massachusetts employers. So the stated purpose of the act is to ensure, promote pay equality between genders. So this is a gender statute to equalize compensation between females and males. And it has a lot more provisions, a lot more teeth to it than the current Massachusetts law that's been on the books. So here's the general overview that I'll be walking through in more specifics. The goal is to prevent discrimination in compensation based on gender. Massachusetts, we already have an Equal Pay Act. The new statute clarifies what constitutes discriminatory pay practices and imposes several new rules and restrictions on employers, specifically during the hiring process, in terms of what kind of information you can request for compensation history, and there's some significant restrictions that we'll be going through. The existing law does not define comparable work. So the guiding principle overall is that there should be an equality of pay between genders for quote-unquote comparable work. The Equal Pay Act in Massachusetts that's on the books does not define comparable work. This act will. The existing law only provides for seniority as a basis for varying compensation. The new act provides for 6 justifications for variable pay between genders. The act restricts what employers can ask about applicants' pay history, particularly during the hiring process. The act makes it unlawful to prohibit employees from discussing wages, which is also, that's not as groundbreaking as someone may think, because under federal law, under the NLRA, the National Labor Relations Board has been very aggressive in protecting, under Section 7, employees' rights to discuss compensation amongst employees. Importantly, and we'll get to this later, the new act provides an affirmative defense to any claims under the statute for employers who have conducted a pay audit. And so you'll have you have until July 1, 2018 to get that in order. The Act raises a lot of questions about how to comply, the meaning of the Act, specifically how to conduct that pay audit. As of right now, the Attorney General's office, which has been charged with issuing regulations, has not issued any regulations yet. There's been no guidance yet from the Attorney General's office on the Act. There's been no regulations. So we're waiting for that to fill in some, and presumably that'll fill in some of the blanks and some of the color of the Act. So here's the basic prohibition of the Act. An employer shall not discriminate in any way on the basis of gender in the payment of wages, or pay any person in its employ a salary or wage rate less than rates paid to its employees of a different gender, so it's tied to gender, for comparable work. So the two key words in that prohibition are what are wages and what is comparable work. If you have a situation where the Act provides that if you have a situation where there is a differential between genders, employers are prohibited from reducing the higher paid, presumably male, to create gender equality, to create pay equality between the genders. So wages, one of the first two phrases. The term wages is to be defined broadly to include all forms of remuneration for employment. So when you look at that, what are wages? You're looking at hourly wages, you're looking at salaries, you're looking at bonuses, commissions, health insurance, and other fringe benefits. So a broad spectrum of compensatory compensation benefits will all get wrapped up into the definition of wages, which will be the metric by which any comparison between a male and a female's compensation will be made. Comparable work. I said the current statute in Massachusetts does not define comparable work. The new Act defines comparable work as work that requires substantially similar skill, effort, responsibility, performed under similar conditions. So it's comparable work is work that requires substantially similar skill, effort, responsibility, performed under similar working conditions. Now the statute does, within its text, recognize that there could be reasonable pay differences for shift differentials. So if you have a female working a day shift, comparing her compensation to a male working an overnight night shift, the law does recognize that you can have a reasonable difference for pay if you're paying the night shift people. That's typically a position that gets a premium pay to work those hours. So something like that, as well as you can account for physical surroundings and hazards facing employees. A job title, a job description alone shall not define comparability. And the statute is built around, the definition of comparable work is built around work that's, quote, substantially similar. Substantially similar is not a defined term in the Act. So I said that there are 6, unlike the current Equal Pay Act in Massachusetts, the new Act has 6 defined, stated differences that you can justify pay differentials in when employees are performing comparable work. So you can have a valid seniority system. That will be a justification for a pay differential between employees performing comparable work. The statute specifically says that any person out on a pregnancy-related disability condition or protected paternal family medical leave shall not reduce seniority. So in terms of a seniority system, those kinds of leaves count towards seniority. You can have a pay differential that's based on a merit system. You can have a pay differential that's based on a system that measures quantity or quality of production, sales, or revenue. So if employees are working on a piece goods, are being compensated on a piece goods basis, or being compensated on a sales basis, where you're measuring compensation is tied to a measurable data point in terms of number, that is a legitimate basis to have a pay differential. statute recognizes that geographic location of the job performance would be a basis for reasonable differential and for comparable employment, and education, training, or experience relating to that specific job, and travel if necessary. So those are 6 specific bases that are in the statute that would allow for a reasonable differential for comparable work. Note that the Federal Equal Pay Act includes this sort of catch-all phrase of any factor other than sex as a justification for having a gender-based pay differential. Massachusetts Act does not include that umbrella. So in Massachusetts, you're going to be tied to, if there is a pay differential between genders for comparable work, you're either going to have to be under one of those 6 enumerated justifications, or you'll likely be in violation of the Act. This statute, unlike discrimination statutes, does not have intent as a requirement. So in other words, an employee who feels that brings a case that she's being not comparably paid for similar work will not have to prove an intent to discriminate on the basis of the employer. In doing your analysis, basically 3 steps to look at: are the jobs comparable under the definitions in the Act? Is there pay equality between men and women? And if there's a pay differential, is it justified by one of the 6 exceptions? So all you employers, you HR people, as of July 1/18, you should be going through that analysis if you have pay differential between a female and a male. Employer liability, under the Act, there's a liability for the unpaid wages plus an equal amount as liquidated damages. I'm going to move through some of the litigation issues because I'm running out of time, to get to the assessment tool that will provide a defense. But an agreement by an employee to work for less than a comparable wage shall not be a defense. Similar to the Wage Act, if anyone's familiar with the Wage Act, you can't have a contract that avoids the Wage Act liability. The employee's previous compensation history shall not be a defense, and there's a 3-year statute of limitation. Some of the things that the Act prohibits employers from doing is to, as I said before, prohibit employees from discussing their own compensation. So check your company handbooks, make sure you don't have any provisions in there, either under confidentiality or anyone else that would state or would be reasonably construed to chill employees' rights to discuss compensation, their own or others. You cannot, during the hiring process, seek the compensation history of a candidate. You cannot require that a prospective employee's compensation history meet certain criteria. So this is, I talk to clients who are to do the hiring. There's a lot of questions about, how do we approach under this Act? How will we be able to approach compensation history and suitability for a position based on compensation history? And as of right now, pending regulations or guidance, you basically cannot, unless the employee, the prospective candidate, has voluntarily disclosed his or her own compensation history. Then the employer is permitted to confirm it. And you may confirm prior compensation after an offer of employment has been negotiated and made to a prospect. So basically, in other words, you can't make a hiring decision, you can't make an offer of employment with compensation based on employees' prior compensation history unless it's been voluntarily disclosed. So here's an important point for all employers between now and July 1, 2018. The statute provides a safe harbor, complete affirmative defense to any claims under the Act for employers who have, within the previous 3 years, conducted a pay equality self-evaluation. And what that means is, to be under that, you have to, the employers are encouraged to do a complete audit of their pay practices, identify whether there are any disparities in compensation, in pay between women, between genders, and take reasonable steps to remedy that on their own. If you've done that and can demonstrate that, you will have, as an employer, a complete affirmative defense to any claims under the Act. Now, to have a complete defense must be done in good faith. It must be done, this is the pay survey, in reasonable in detail and scope in light of the size of the employer. And if the employer cannot demonstrate that if an employer who undertakes such an evaluation but is unable to demonstrate that it was reasonable in detail and scope, you will have a partial defense, not a complete defense, and under those circumstances, an employer may still be liable for single damages, but will not be liable for the double damages, for the liquidated damages. And evidence of the self-evaluation and remedial steps will not be admissible in evidence. We encourage, and not just feathering our own bed, but I've been to Attorney General's, Office of the Attorney General's presentations on the statute. Companies are highly recommended that a pay audit be conducted under the auspices, under the guidance of outside counsel, under the guidance of counsel, whether inside or outside counsel, in order to protect the attorney-client privilege as to that pay audit. Right now, we don't know what is going to be considered reasonable in detail and scope, pending having regulations come out from the Attorney General's office. So it's been common wisdom right now and common advice to employees to hold off right now on doing the the compensation survey pending the regulations, but larger employers, it's going to take, this is going to be a project that's going to take some time. We're still 14, 15 months out, and we'll be, we're obviously watching for the regulations and to get some detail and some meat on the bones around what is going to be a reasonably detailed pay equity survey in order to provide employees the affirmative defense. So you should have that on your radar. We'll be sending out alerts, but it's something to be mindful of, and we hope that the Attorney General's office will be issuing regulations soon. I'm not aware that they've set any date, but by which they will come out, but they will be, and we'll be monitoring it. So that's my time on the Pay Equality Act, and Tamsin's going to talk you through workplace investigations.
Thank you, Gary.
All of you are familiar with workplace investigations. You may have conducted them yourselves, or you may have brought in investigators or counsel to conduct them for you. As you know, workplace investigations are critical in response to allegations of unlawful discrimination or harassment in your workplace. Should there be such complaints, should there be such allegations, the employer is required to investigate, to address, and to remedy the problem. Complaints, however, cannot be kept confidential. So if a complainant comes to you and says, here are my issues, here are my concerns, please don't tell anybody, what do we tell them? We tell them, I will keep this confidential to the fullest extent possible. However, we have an obligation to investigate what you have brought to our attention. That's a very important piece. I know sometimes it's difficult because people come to HR, they want to confide, and of course you want them to trust you and to be open, but we must be honest that we cannot keep this information confidential, because although we will respect their privacy to the fullest extent possible, we must investigate. Now, one of the common practices in workplace investigations is to instruct complainants and instruct witnesses that they must keep all of the conversation in their interview within the scope of the investigation completely confidential. And I know, talking to my clients and being out in the field, that this is still a common practice for investigators and for HR folks to tell everyone they talk to during the scope of the investigation to keep the conversation confidential. This is not legal. And the reason is because, as Gary mentioned earlier, under the National Labor Relations Act, employees have a right to concerted activity, protected concerted activity under Section 7 of the National Labor Relations Act, which means that protected concerted activity occurs when employees take action or engage in any communication for for their mutual aid or protection regarding terms and conditions of employment. And it has been held that this includes the employee's rights to discuss disciplinary investigations with fellow employees. Hence, under the NLRA, employees have a legal right to talk about what's going on in the investigation, what's going on with respect to issues in the workplace, terms and conditions of employment, and potential discipline that may arise from the investigation. So how do we deal with this? The way we deal with this is that we keep in mind that blanket confidentiality is not lawful, and instead we need to do a certain amount of legwork up front before we start the investigation to determine whether a confidentiality instruction is appropriate and lawful. And a case called Banner Health System has spelled out for us exactly what we need to do in order to make the initial finding that a confidentiality instruction is appropriate as we go through the investigation. What I recommend for my clients and what I do when I'm brought in to investigate workplace allegations is that we document this initial threshold analysis in a memo that goes into the investigation file. Here's the way it works. Before instructing the claimant or any witnesses to keep workplace investigation confidential, you must, or your investigator must, conduct a case-specific analysis to find that non-disclosure is necessary because of one of these reasons. Confidentiality is necessary because there is a need to protect a witness or witnesses, because there is a likelihood that evidence will be destroyed, because there is a threat that testimony from witnesses could be fabricated, or there is a need to prevent some kind of a cover-up. In my experience, you are going to find one or more of these grounds for a confidentiality instruction in almost every situation. But it is a requirement that you do this analysis, and I recommend as a best practice that you document the analysis, document your findings, again, before the investigation occurs, before you give anyone a confidentiality instruction, any of your witnesses or the claimant. And then as you go through the investigation, I've done some workplace investigations that involve over 100 witnesses. So as you're going through the investigation, circumstances change, you become aware of new facts, and a reanalysis or revisiting of this analysis periodically throughout the investigation is appropriate and helpful and should be documented so that if new facts come to light, you can take that into consideration in your analysis of your confidentiality instruction. There's a lot more that we can discuss with respect to workplace investigations. It's a complex area, and I caution you to be sure that you have all your ducks in a row, that you've talked to your counsel, that when appropriate you've brought in a neutral fact finder to conduct your investigations so that your investigation is done properly, is documented properly, and will withstand scrutiny should there be a legal claim.
Well, good morning, everybody. This is the infomercial portion of the program. This is going to be very quick. We were expecting that there were going to be significant changes to the overtime laws before the new administration came in. And now, since he's very unpredictable, we don't know when and if this change is going to happen. But right now, there's an issue as to whether or not the new regulations, which, if some of you may be aware, was going to increase salary requirements for somebody who's exempt from overtime to $47,000 versus what it is now, which is roughly $23,000 and change. That's all on hold. There was an injunction entered. The Department of Labor's reply brief is due on June 30th, 2017. The Department of Labor is deciding now whether it's going to continue along with the case. It's got to make a decision whether or not it's going to rescind the program, go ahead with the litigation or not. And the key issue in the case is what the concern is whether or not that new salary requirement of the $47,000 and change effectively set up a new test, which was a de facto salary test. What Congress had established in the statute was that whether or not you were exempt was dependent upon the duties of the employees. And that is what is up there was the EAP, which is executive, administrative, and professional. There are also some tests for computer, outside sales, and highly compensated. But those are the keys. You have to have an employee fit as either an executive capacity, administrative, or professional. The statute's pretty particular about how you meet that standard. I don't have time to go into that today. That was a topic that we went over last year. But the concern here is that when they set the salary at $47,000, that essentially put a threshold. That itself was a separate test. And the contention is that under the legislation, the DOL was not allowed to add an additional test like that. And that's what the fight's about. Remains to be seen where that's going to end up, but it's the way it was, as the way it has been now for a number of years. You got to meet those tests. One thing to keep in mind, a lot of people think that salary is the key, that if I pay my employee a salary, they're exempt. That's not the case. They have to fit into a qualification of executive, administrative, professional, computer, highly paid. Those are the possible outcomes I mentioned, which is the legislation that Congress delays or blocks the rule, or the Department of Labor abandons it or rescinds the rule. So that's the infomercial. Now will be the, I apologize in ahead, highlight of the morning. Gary's going to talk about marijuana in the workplace.
Thank you, Larry. Before I start, it's the appropriate place for me to acknowledge a glaring omission in my introduction. I forgot, I neglected to also introduce a member of our team, Dave Rogers. Dave wasn't sitting here in the front row when I introduced everyone, and now I look up at the marijuana topic, and of course I'm reminded of Dave because Dave also, in addition to practicing law, is a representative up on Beacon Hill. He's been instrumental in the legislation, in the movement and the legislation passed that the Beacon Hill's working on to legalize recreational marijuana. Dave has been appointed to one of the members of the Joint Commission of the Senate and House, looking at the referendum and making recommendations and actually writing the bill. So that's why the marijuana in the workplace title made me think of Dave Rogers. So I presented on, this topic has been presented on, I think, probably several times before this year. It keeps coming up. It remains to this day to be one of the biggest challenges employers in Massachusetts and across the country have in dealing with employees, what to do about marijuana usage and drug testing that results in a positive test for marijuana. Since I last presented, or we last presented on this last year, there's been big change in Massachusetts. There's been no change at the federal level, and there's been little change for employers. So the big change in Massachusetts, everyone should be aware that we now have legalized adult use recreational marijuana allowed in Massachusetts. No change at the federal level, meaning that marijuana is still classified as a Class 1 drug under the drug enforcement laws, under the Controlled Substances Act at the federal level. So while marijuana has been either medical or adult use recreational, has been legalized in many states, overriding that all, it's still treated as a Class 1 unlawful drug under the Controlled Substances Act. So that presents some very difficult questions without many answers as to how employers, what are the legal guidelines around dealing with marijuana use among your workforce. So now in Massachusetts we have legalized medical marijuana, and now we have legalized recreational marijuana. There are no, on the recreational adult use side, it's legalized now. There are no stores, retail stores, dispensaries that are open yet, and that's been pushed back, I think, till mid or end, I forget now, July or December of 2018. July 2018 is the date by which legal adult use stores are to open in Massachusetts. So I'll start with medical marijuana first. The marijuana statute specifically says on the medical side that nothing in the law requires any accommodation of any on-site medical use of marijuana in any place of employment, or the smoking of medical marijuana in any public place. So you cannot, employers are not compelled to permit on-site medical use at any place of employment. So where this comes up for employers, and like I said, this is one of the most frequent issues I deal with my clients, is what do you do with an employee who has tested positive for marijuana, or prior to a testing comes in, says, I'm a medical patient, I've complied with Massachusetts law, I have my medical marijuana card under Massachusetts law, and I'm allowed to use marijuana. Under the federal law, particularly the ADA, so you look at the Massachusetts 151B handicap statute, which, similar to the ADA, requires employers to provide reasonable accommodations to employees with a serious medical condition. Under federal law, an employee is not entitled to use medical marijuana as a reasonable accommodation. But here we have state law which specifically allows for medical marijuana. And so the question employers face is there an obligation to make a reasonable accommodation to an employee who's got a medical condition and uses marijuana, whether during the day for an ongoing chronic condition or even at night on their own time outside the workplace, but will show up at work the next day or the next several days or weeks and likely test positive for marijuana, even though there may not be, even though in any that situation there's no marijuana use, there's no impairment while on the job. So at the federal level, all courts that have addressed this issue in states that have medical marijuana laws have concluded that there are no rights under the ADA. Marijuana is illegal under federal law. So under the federal ADA, marijuana use is not permissible to justify or require a reasonable accommodation, and employers are still free to terminate any employees who test positive for marijuana in violation of law or policy at the federal level. You know, at the state level, we do not at this point have any binding guidance from the courts as to what to do in Massachusetts. You know, there's now a case pending before the SJC, the Barbuto case. It's been widely reported in Massachusetts. Just quickly run through that. This is a situation where you have an applicant for employment in a non-safety sensitive position who was, I believe, provided a conditional offer of employment subject to drug testing. This particular prospective candidate suffers from Crohn's disease, has a medical marijuana card, is licensed and permissible to use medical marijuana to treat her Crohn's disease. She, subject to her offer of employment, she went through pre-employment screening, tested positive for marijuana, and the company pulled the offer and terminated her. She sued under 151B, claiming a violation of her rights as a handicapped person, that argued that the employer was obligated to provide her with a reasonable accommodation and allow her to use medical marijuana. And she also brought a claim for a violation of the Privacy Act, challenging the drug test itself, as she was a person in a non-safety sensitive position, and this wasn't a case of reasonable suspicion. Obviously, you know, she hadn't even started work at the time, so there was no issue of her being impaired on the job. At the Superior Court level, her handicap discrimination claim was dismissed. It was appealed. The SJC took it on direct appellate review. The case was argued probably about 4 weeks ago, approximately, and we're waiting for a decision from the SJC as to how that issue is going to be handled strictly as an issue under Massachusetts law.
Gary,
Now,
she wasn't looking to use marijuana while she was working, right?
I don't believe so.
She was
think
not.
it was-
Absolutely
She was not.
Yeah.
She
So-
only used it at night.
Okay, so
And it was to stimulate her appetite.
so Crohn's disease, I associated that with someone who would be using marijuana during the day, but in this case, Ms. Barbuto was looking to use marijuana only at night for her appetite. There are other medical conditions where there will be recommended treatments of using marijuana during the day, and there are some medical conditions where the recommended treatment will be such for anxiety, depression, things like that, and in this woman's case, use it only at night. So that's an important distinction, because if the use of marijuana is limited to off-duty hours at night, that person's not going to show up at work the next day impaired in any way. But that person will show up and will not be able to pass a drug test, as Ms. Barbuto was. So now we have recreational use in Massachusetts, or adult use. And so adults may possess and grow marijuana in their homes. Adults may possess marijuana outside their homes. Retail stores will be opening, at least as of right now, not before July 18th. The statute specifically states that employers are not required to permit or accommodate marijuana use by employees, and employers are not restricted to enact and enforce workplace policies restricting the consumption of marijuana by employees. We know the statistics show that marijuana use among adults has been increasing over the last several years. It's likely to assume that once the law is in effect now legalizing recreational use. Once stores start opening, you can assume that marijuana use among adults may be on the rise. So how does that affect you as employers in terms of your drug policies, your drug-free workplace policies if you have one, and your testing protocols for employees, as well as what do you do when you've got someone who is either appears to be impaired, or you're doing a random drug test during the course of employment and that employee tests positive for marijuana and then produces a medical marijuana card. So Massachusetts law does not, while it decriminalizes marijuana, you're not required to permit use. It's illegal under federal law. Your drug-free workplace policies are still enforceable. But the question then, is it wise, and what should employers do in terms of drug testing policies? There's been a lot of talk and writings about if, for employees in a non-safety sensitive position, employers should consider eliminating marijuana as part of the testing protocol, because what you're going to face is you're going to face a substantial number, a measurable number of employees who are going to test positive for marijuana, which does not indicate impairment during the job, during the time of work. And are you going to be, as an employer, unduly restricting the available workforce, the available work pool, if you're going to eliminate from your hiring process or your ongoing employment workforce every single adult who tests positive for marijuana use without any indications of impairment on the job? So I've been talking to clients, most of whom have been receptive, of just in non-safety sensitive positions, just eliminating marijuana as part of the drug testing protocol. Your managers should still be vigilant and alert for impairment on the job, for someone who shows up at work or during the day, either appears to have an odor of marijuana, any signs that indicating marijuana use during the workforce, during the workday, you should take action on that. But you're opening up you're diving into a hornet's nest if you're going to continue to test non-safety sensitive employees for marijuana. So instead of a drug-free workplace policy, consider a no impairment policy. And you probably all know that the issue with the drug testing for marijuana specifically is that there's no correlation between a drug test for marijuana and current impairment, like there is with a breathalyzer or drug tests for narcotics or other illegal drugs. Situation I've faced with a number of clients when you have on the realm of medical marijuana, when you have, say, employees in a safety-sensitive position who could be using equipment, could be driving vehicles, either random drug testing or pre-employment test positive for marijuana in a safety-sensitive position. If you have relevant policies, appropriate policies as an employer, you're still free to terminate that employee as of right now in Massachusetts without any fear, pending what the SJC does in the Barbuto case. You have to make sure that any action you take is based on the marijuana use and not because of the underlying disability, and you don't want to open yourself up to a claim for disability discrimination. And one thing that I've been doing with clients is that we've had several situations where there's been random drug testing of employees in safety-sensitive positions. They fail, then they come in and say, oh, well, I have a medical marijuana card, and here it is. So then the employer's faced with the situation, someone's got a serious medical condition, got a medical marijuana card, tested positive. So one thing that some of my clients have done is they've reached out to the employee's doctor through the employee as if it was an ADA impairment situation, and we sent the doctor one of the ADA impairment checklist forms tailored for this, and basically asked the doctor to tell us, with the employee's consent, what's the condition and what has been your recommendation. Why did you certify this person for medical marijuana use, and what's your recommended prescription? Is it a condition that you've told the employee to use marijuana during the day to relieve an ongoing chronic disease, illness, or is it something that you've recommended the employee to use only at night to help sleep or to reduce anxiety at night? And in those instances where we've gotten information, signed authorization, and signed report back from the prescribing doctor that the use was needed and prescribed only for nighttime use, in most instances where we had good employees who failed the drug test, the company has relied on that and still been vigilant to watch that there's been no impairment during the day, but with the doctor's note that the required use and the reason that employee has a medical marijuana card is to use marijuana at night. In those instances, the clients have typically continued the person in their job. So the law is expanding on allowing legal use of marijuana. The employment laws so far have not been really keeping up. It presents a lot of questions, and it will continue to present questions until we get some definitive guidance from either the courts or if the federal government makes any change to the Controlled Substances Act, which with current administration is probably not likely to happen. Okay, I see a question, Ellen?
Yeah, I definitely can.
Go ahead.
Just
Sure.
have a comment, because immigration falls under federal law, that even though it's permissible, perhaps under certain circumstances statewide, that there could be issues on the immigration. So if you have employees who have visas or are here as immigrants on any type of status, I don't know if you've come up against that, but that's, I think, on notice, an alert to show that it could be permissible mass. And also the next thing, is there any mandatory reporting on behalf of the employer where it could sort of go into the hands?
I'm not aware of the reporting. I didn't get into it here, but there are federal statutes under, for instance, Department of Transportation regulations that if you have employees driving DOT-regulated trucks, which are over a certain tonnage, you're required as an employer to do drug testing, and you're required to take action if an employee fails a drug test, and that employee is subject to the DOT safe roads testing protocol. So the federal scheme is much different than the Massachusetts scheme. Right. But to answer your question about reporting, I'm not familiar with whether there is an affirmative obligation to report that to the DOT. I'll be here after. We'll pass it back to Tamsin.
I couldn't agree more with Gary's suggestion that you be very careful about testing for marijuana in non-safety sensitive positions, and particularly in light of Barbuto and in light of other case law under the Privacy Act. It may very well be that testing individuals in non-safety sensitive positions for drug use violates their privacy rights under the Massachusetts privacy law. Also, I think Gary's idea of getting a doctor involved if somebody tests positive for marijuana and you're concerned about their safety in the workplace is a fantastic idea, because you can rely on their doctor's documentation. And I would suggest that in addition to asking the time of the day that the marijuana is used, that you consider asking the doctor directly in what way this affects the employee's ability to do their job. And just like with an ADA questionnaire, you send them a job description so that the physician is aware of what the job requirements are and can opine about the individual patient's ability to do that job safely. Okay, so moving on to social media and related policies. Why are we concerned about employees' use of social media and the internet? We're concerned because they can use it to sexually harass or discriminate against other employees, because excessive use of social media or the internet for non-work related reasons can cause a problem with decreased productivity, with attention, with quality of work, with breaches of confidentiality. If social media postings are including potentially confidential information about your business, about your trade secrets, etc. We're concerned because of potential disparagement of the company, disparagement of coworkers, disparagement of vendors or customers, disparagement of your products or services by the employee using social media, using the internet, potentially damaging your brand, potentially damaging your reputation in a public forum. And obviously we're concerned about potential criminal activity as well. So these are all the good reasons why we're concerned and why it's appropriate for employers to have policies that effectively, and because of the law that I'm going to talk to you about, very carefully address our needs and protect our company, protect our employees, but at the same time respect the rights of the employee who potentially is using the internet or using social media. So we want to have electronic equipment policies, internet use policies, email policies, social media policies, and personal electronic device policies. All of these should be present in a good employee handbook. And I've worked on all of these policies many times with my clients. But beware. The reason that this is a very tricky area is, again, Section 7 of the National Labor Relations Act, protected concerted activity. Again, employees in an employer's workplace of any size, regardless of whether the workplace is unionized or non-unionized, employees have a right to protected concerted activity. Again, protected concerted activity is when employees take action or engage in communication for their mutual aid or protection regarding terms and conditions of employment. And the National Relations Board is very aggressive about making sure that employers' policies restricting use of email, internet, and social media don't in any way deter or infringe on your employees' rights to concerted activity. So one case that we have under the National Labor Relations Board is Purple Communications. And in Purple Communications, the NLRB held that employee use of email for statutorily protected communications, concerted activity, on non-working time must presumptively be permitted by employers who have chosen to give employees access to their email systems. If you let your employees use your email system while they're working, during work hours, you are presumptively required to allow those same employees to use your email system to communicate among themselves about their terms and conditions of employment on non-working hours. You don't have to permit them to do this during work time when you're paying them to work, but you must give them access to your email system to engage in concerted activity, to discuss terms and conditions of employment on off hours. So there's a presumption once you give access to email for work reasons that you will allow your employees to use that email system for concerted activity during non-work hours. Again, not something that people commonly do, not something that I find employers are commonly aware of, so beware. Some of the policies that we see in employee handbooks that have been found to be unlawful by the NLRB are quite common policies, and it's surprising and sometimes confusing. But under National Labor Relations Act law, the NLRB has found the following policies to be unlawful. A directive to employees to, quote, avoid harming the image and integrity of the company. Now you would think that that goes without saying. That's a very common type of directive to your employees. The reason the NLRB is looking at that and saying that could potentially restrict or chill concerted activity is because it's subject to interpretation by an employee that they can't post information on social media or email or use the internet to discuss terms and conditions of employment. because discussion of those terms and conditions of employment may negatively reflect on the image and integrity of the company. So since it's subject to interpretation that could potentially chill concerted activity, the NLRB says, no, this is an unlawful policy. Another common policy that you would think would be perfectly appropriate, prohibition on employees posting online information about the employer that could be deemed, quote, material and non-public, or, quote, confidential or proprietary. Again, the NLRB has held in this specific instance that this is language that is susceptible to an interpretation by the employees that would chill their concerted activity, that would chill their right to engage in discussion of terms and conditions of employment. So these are too broad, they're too general. The third example, again, something that is common, seems like an obvious policy that you would want to have, the NLRB has said is unlawful. It's a provision in an employee handbook stating that offensive, demeaning, abusive, or inappropriate remarks are out of place online as offline. Okay, I mean, give me a break. Obviously, we don't want our employees engaging in offensive, demeaning, abusive, or inappropriate remarks. However, as remarkable as it is, in that particular case, the NLRB found that this was too general and that it could chill concerted activity. Recent case, 2017 case, just the last couple of months. All right, here's what happened. Supervisor spoke harshly to an employee 2 days before a union certification election was to take place. The employee's Facebook post stated that the supervisor is such a nasty mother effer, don't know how to talk to people, F his mother and his entire effing family, what a loser, vote yes for the union. Okay, how would you like it if your employee posted this? You probably wouldn't like it very much. And in fact, you might terminate that employee under your harassment policy, which is exactly what happened in this case. The employer terminated the employee for violation of the company's harassment policy. Was that found to be unlawful by the National Labor Relations Board? Do you think so? Yes, indeed it was. Because, again, this was a discussion of, according to the NLRB, protected concerted rights, protected concerted activity, employees' rights to discuss terms and conditions of employment, to communicate for their mutual aid and protection. So it's unfortunate that he used this kind of language, but the NLRB says this posting does not lawfully give rise to termination. So what do? Very clear guidelines for all of your internet and social media related policies. Be clear that the rules do not prohibit concerted activity. Employees, here's something that you can say, employees may not blog or post during business hours. You can say there's no expectation of privacy when connected to the workplace. You can say that disclosure of trade secret information is prohibited. You can prohibit using company email addresses to register for social media sites. And again, you can prohibit non-work related use of email during work hours. You can prohibit the posting of false information that is not true about the company or its employees, customers, or vendors. It is advisable to provide specific examples of what is prohibited, such as discriminatory remarks, harassment, threats of violence. Mandate that employees keep company logos off their personal blogs and personal webpage, and always identify a contact person to address questions about internet and social media policies. Again, we really need to scrutinize all of these internet and social media policies in our employee handbooks. Policies that seem to be obvious and common sense may in fact be unlawful, may chill concerted activity. There is a model social media policy that was issued by the NLRB some years back. I have modified that to some extent, and I use it with my clients. If anyone would be interested in seeing that model policy, feel free to reach out to me and I'd be happy to share it with you. That's it for now. Who's up next? Robert. Yes, Kevin. You want me to go back?
Those clear guidelines that you recommended, Have there been specific NLRB rulings on each of those? Those
Yes.
okay?
Yes.
Could I just one point, go
Yes.
back one further slide. So my memory, Tamsin, is that first bullet point where policies say at the end of a policy, nothing stated in the social media policy
I'm
shall
glad
be
you said it.
construed
It's not
as
a magic
violating your
bullet.
rights.
That is not a magic bullet.
Right, that you cannot safe harbor yourself just by putting that
Right.
in there. The NLRB has said that is not sufficient.
not
To
sufficient.
state that nothing here shall be violating your rights is not sufficient
That's right.
in and of itself.
I still recommend that you include it,
Sure.
but Gary makes an excellent point. That is not a magic bullet. That will not protect you. Thank you.
Good morning, everybody. Again, my name is Robert Cates. I'm the rookie for the employment law team. And as the rookie, I was drawn to talk about the new I-9 form. I promise you it will be brief. I think the reason why we wanted to include it was because it was identified as causing certain issues, which hopefully were clarified with the new I-9 form. There is a new I-9 form at the back of the booklet on the right side that you've all been provided. And again, I will be brief. I'm going to probably say that about 5 times just because I want to emphasize it. We'll have plenty of time for questions. The basics of the I-9 form is that it serves 2 purposes, both to verify an employee's identity and to verify their authorization to work in the United States. It does not apply to independent contractors. It only applies to employees or subcontract. It does not apply to subcontractors either. It's administered not by the Department of Labor, but rather by the United States Citizenship and Immigration Services, the USCIS. It's mandatory to be completed by each employee in the United States. The employer is responsible for that and may be audited for it and may be subject to penalties for failure to comply. According to the Department of Labor's estimates, 61 million individuals are employed in the United States as new hires every year. I'm sure most, if not all, of us in this room have filled them out, maybe recently as well. The I-9 form is available in both English and Spanish. However, for purposes of filling it out and saving a copy for the employer, it must be done in English. The lone exception is in Puerto Rico, where it can be filled out in Spanish for anyone who works with companies in Puerto Rico. The new I-9 form was sent down by the USCIS in a directive in November 2016 to take effect January 22nd, 2017. I would hope that for any of the human resources professionals in the room, they've been using it since then, but if you haven't, now's your chance to make it right. Part of the objective was to make it more smart and user-friendly, so it can be filled out in part online using drop-down boxes for ease, just filling it out and making sure it's complete. There's also expanded instructions on the USCIS website. I believe that the USCIS felt that there were certain problems or confusion that was arising from the form, so they wanted to have expanded instructions. Regardless of whether it's filled out online or by hand, it still needs to be printed out, signed by the employee, signed by the authorized representative, and needs to be a hard copy needs to be held onto by the employer. Another stated instruction from the USCIS was that they wanted to prevent the risk of invasion of privacy to transgendered individuals. I'll explain how in a second. I guess the question that everyone also asks when we talk about late 2016 federal directives is, how is the new administration going to impact it? There's no indication that there will be any change based on the new administration. The only thing I would caution is when we're talking about the USCIS, it will be more expanded and might be more aggressive in certain employment authorization issues. Now, I'll be talking and citing to the I-9 form at times. So in section 1, which of course is what the employee fills out, the most important change was, rather than it saying other names used, now it clarifies to say other last names. And the reason that the USCIS gave was that it wanted to be clear that they're not looking for change of first names, which might either lead to discriminatory decisions or an invasion of privacy of a transgendered individual. There's also a change in terms of what documents an alien needs to provide. Previously, if the alien had only the admissions number, the alien was also required to provide his or her foreign passport number. Now there's an either or as opposed to a both. And finally, to eliminate some confusion, there is a checkbox for an individual who prepares Section 1 who did not require any translator or preparer. With regards to Section 2, which of course the employer will fill out, there's a new citizenship/immigration status box that's at the top right corner. And for ease, if you have someone who is a citizen, you just write 1, or you can just select 1 from the drop-down box. There's also an area in the middle of the page that has a big blank where it says additional information that generally relates to visa classifications, TPS extensions, OPT STEM extensions, H-1B portability. So that's again for the employer to fill out based on certain visa considerations. And then in Section 3, this is only for re-verification, where someone's employment authorization document expires, or if they've been rehired, if they've separated from employment. I believe it's over 30 days. It's fairly simple. Just need to follow the steps, and where there's no information needed, just a not applicable does a day. So I thank you all very much for bearing with me as I went through this stimulating exercise, and it's my pleasure to turn this over to Larry to talk about the Trade Secret Act. Yes?
Just one acknowledgement on the form, on the I-9 form, on the top right-hand corner, it has the expiration date of 8/31/2019. And if you look at the bottom left side, 11/14/2016. So what happens is sometimes USCIS updates the form, so you'll see the same expiration date, but the date on the bottom left will be changed. So if you don't notice the updates and you submit a form that even though the expiration date hasn't happened, but you haven't submitted the updated one, USCIS can deny the application, or you'll have to redo it. So it's important to go online, literally the day of, to see if the bottom left-hand corner date had any updates. So a lot of times people are tricked up because they say, oh yeah, it's not past the expiration date. But the bottom left-hand corner, there were updates, and then you end up submitting an outdated form. So just wanted to highlight the date issue.
That's perfect. Thank you for tying that all up.
Okay, so I'm here to talk about the Federal Trade Secrets Act. It was enacted in 2016. The reason we're talking about it is I tend to still see that some employers haven't updated their documents to help get the protections they can get under this statute. So we thought it was worth kind of going over and reminding people that it's out there and what you need to do. So what this act does is it provides a federal cause of action for trade secret misappropriation. Now, trade secrets are different than just generally confidential information. You have to take certain steps in order to protect the information to make it a trade secret. You limit who has access to it. You're clear in identifying it, that it is a trade secret, that it's to be kept strictly confidential. What this act adds, which did not exist before, is an ability to go in ex parte, which means without notice, to get a seizure against an employee who may be misappropriating, or somebody else, to seize the information that you're saying that person has and is trying to disclose as a trade secret. There's a lot of specifics about how to go about doing that, which is more in the lawyer's purview. I won't bore you with that. But it does give you that ability to act very quickly and stop a trade secret from being disclosed. The other aspect that this act does is it does give some protection to employees. And what they decided to do is that you have whistleblowing employees who may be reporting about an unlawful activity, and in order to do that, they may have to disclose information that could be a trade secret. And what this statute does is give some protection to whistleblowers if they are disclosing a trade secret in certain respects, and we'll go through that in a second. The other interesting thing what this statute does is it prohibits an employer from getting injunctive relief based on what's known as the inevitable disclosure doctrine. And what that means is that you make the argument that because this employee is aware of this trade secret information, if he or she works for another company in a similar area, it's going to be inevitable that they disclose this information because it's in their head, it's in their memory. This statute expressly says that that is not a basis to get an injunction. You would have to show that, in fact, there was a misappropriation and an intent to disclose the trade secret information in order to get the injunction. So just knowing about it is not enough. So what's the benefits of the Trade Secrets Act to employers? First of all, if you put in a disclosure about the whistleblower immunity provisions, which is the provisions that outline when a whistleblower can disclose information, then it gives you additional benefits that you can recover against that employee if they, in fact, disclose a trade secret without complying with the whistleblower immunity provisions. It allows you to recover double damages. It allows you to recover attorney's fees. This would also work whether or not the employee who misappropriated was not whistleblowing but disclosed. Again, if you have the whistleblower immunity in your documentation, then if you are suing an employee for a breach, again, it allows you to get double damages and attorney's fees. The Act allows you to bring a case in federal court. Some would say the federal courts are more direct and efficient in handling these types of cases, and you might be able to get quicker relief in those cases. Massachusetts does have its own trade secret statute. It's not the Uniform Trade Secrets Act. They did not adopt that, which this federal statute is an adoption of, but it does have its own provisions, its own definition of trade secrets. I will say the definitions, if you have a trade secret, it should fit under, whether it's a definition under the federal statute or Massachusetts statute. You certainly could bring claims under both. But you do get some benefits here under the federal statute by being able to go to federal court. You wouldn't necessarily be able to bring a Massachusetts case against an employee for violation of the Massachusetts statute in federal court. There could be some instances where you could, but generally no. The other thing that employers can get under the statute is equitable remedies, which is injunctive relief, stopping an employee from disclosing, requiring them to return the information, precluding them from working for a company who they may have disclosed information to. Your actual damages, obviously, punitive damages, and attorney's fees. The benefits to the employees under this act, which is it provides an employee immunity from a claim for breach of the statute and disclosing a trade secret if the disclosure is made in the following circumstances. One, you disclose it in confidence to a federal, state, or local government official. So that would be if the SEC comes in and is investigating the company and wants to interview an employee, and participating and cooperating with the government is disclosing a trade secret, that's okay. You can disclose it to your attorney if the purpose is to report or investigate a suspected violation of law. That's the typical whistleblowing situation. Something illegal is going on, I think it should be reported. I can go talk to an attorney and say, here's what's going on, and in part of that disclosure, if I disclose a trade secret, that's okay. And also, you can disclose it again in a complaint, filed in a lawsuit, again under certain circumstances, which is it's made under seal, which is you're asking to the court that I want to file this. It's not going to be publicly available to anybody who can generally go access the case file in the court. It's limited to the court's review. If an individual is filing a claim alleging retaliation for reporting a violation of the law, again, you can disclose that to your attorney, and you can use it in court, again, as long as it's filed under seal or pursuant to a court order. The other thing that this statute provides to employees is that if an employer brings a claim for alleged misappropriation, and it's brought in bad faith. So the employer is bringing the claim, doesn't want an employee to work for a certain company and figures, I'm going to allege trade secret to try to stop that, but doesn't have a good faith basis to do that, and you can show that, well then the employee has the ability, if they prevail, to get their attorney's fees. What's the best practices for an employee to do at this stage of the game? So one, what you should do is you should inventory your trade secrets. Figure out what they are, where they are, and what are the protections that you have in place to keep them from being disclosed. What are the protections you have in place to maintain their confidentiality and limit them being disclosed to employees and watch employees. If you take a trade secret and pretty much disclose it out to all your employees at all levels, it's going to be very hard to argue that it's a trade secret. So trade secrets need to be very, very protected and determining who you allow access to them. And trade secrets could be anything from the formula for your cookies to it could be a process within the company. It could be customer lists. Any of those things could be classified as a trade secret as long as you treat it that way. What you should also do as an employer is document your portfolio management and how effective it is. What's the trade secret? Where is it? What steps are you taking to keep it protected? And what are you continuing to do? So you can lay that out either to the court or even in a demand letter to say, you know, we've taken these steps. It's clearly a trade secret, so we're going to sue or else. And then third, you should develop a response plan. What are you going to do when it happens if there's a misappropriation? So you have set in place, these are the steps we'll take, whether it's we're going to go for the seizure, or at least we know what the steps are to do that, so that you can quickly respond if there's a misappropriation, because once it's out there, you know, you've been permanently harmed. The other best practice is to implement this notice of the immunity and retaliation provisions. These should be included in your employment agreements, your independent contractor agreements, your consulting agreements, any separation and release agreements, essentially any agreement, even your confidentiality agreements. You may have employees that come on and you have them sign confidentiality agreements that they won't disclose proprietary and confidential information as well as trade secrets. You should have in there a provision that discloses the immunity and retaliation provisions. And in your handbooks even. And we find that that's oftentimes not in the handbook. So that's it for the trade secret statute. And next I'm going to talk about access to confidential company documents, particularly in the context of self-help. And what I mean by self-help is where you have an employee who may feel they have a claim of discrimination or retaliation against the company, particularly. You may have an employee who is gathering up emails, making copies of documents and those types of things. And can an employee take those and take them with them, bring them home, give them to an attorney, disseminate them? That's what we're really talking about here. And what the law has determined is that with regard to self-help, self-help can be a protected activity under the discrimination statute. And if it is protected activity, you cannot retaliate against an employee for conducting self-help to basically gather the information that helps support that they have a claim of discrimination or retaliation. In order to have an employee to have that protection, however, the employee's actions have to be reasonable in the totality of the circumstances. So what do we mean by that? Well, what we mean by that is the court is going to take a flexible approach and look at all the circumstances of the situation under which the employee may have taken and copied documents and or given them to their employee or even disseminated them. And it's a balanced approach that the court's going to take. And what the court is going to be looking at is balancing the employer's legitimate need to maintain an orderly workplace, who has access to what documents, that they're kept in the office, they're not disseminated freely, and protect their, obviously, confidential business and client information. And balance that against the compelling need of the employee to be safeguarded against retaliatory or discriminatory actions. So what the courts will generally do is look at 7 factors. One is they're going to want to inquire as to how did the employee come to possession of the document. If the employee was rooting around in the human resource file cabinet, which they would normally not have access to, that would be a problem for the employee. And that would be a benefit to the employer to be able to argue that the self-help was not allowed. Generally, if the employee has general access to documents in the normal course of their job as part of their job, then that is going to be generally looked at as fine by the court. The next factor the court's going to do is balance what's the relevance of the documents to the employee's legal action, i.e., are there emails from the supervisor making discriminatory comments to them versus is it a copy of the spreadsheet showing all the customers they have and the details of their of the sales transaction that you had with those. That's not necessarily at all related to the employee's action. And they're going to balance the relevance of those documents against, again, what's the disruption to the employer's business. So it's always a continually balanced approach. The third factor is the court's going to look at is what's the strength of the employee's reason for copying the document instead of simply describing it to the lawyer or just the government person, or identifying its existence. There's an email such and such a date. There's a file that has this label on it that's got the information in it. So, could you have done something in that capacity rather than copying the documents? Next factor is what did the employee do with the document? Did it disseminate it socially on Facebook, or did it just give it to the attorney? And again, that's a key factor. Did it just give it to the government official, or did it, again, shout from the rooftops and say, here's what's going on, look at this, and throw out the copies of the papers all over the place? The next factor is what's the nature and content of the document that the employee copied or took, and effectively, what is the interest of the employer in keeping the document confidential? If it's an email and exchange, that may be less of a disruption than obviously if it's an actual document that is the trade secret, has the formula on it. And what the relevance might that be to a claim of discrimination or retaliation, I couldn't think of right now, but there could be an instance where, for some reason, that was important to be disclosed to the attorney or government official. The next factor is whether the employee's disclosure violated a company policy on privacy or confidentiality. And then the last factor is kind of the tipping of the balance factor. What a court will do is consider the broad remedial purpose of the statute prohibiting discrimination and the effect of the decision on the balance of the rights between the employers and the employees. So after you go through the 6 factors, then you finally look at this factor and say, where does this balance put me, and does it tip it towards the employee or does it tip it towards the employer? Next is Robert's up again for enforcement.
Good morning again, everybody. I'm just going to talk very briefly about the EEOC's new enforcement guidelines for national origin discrimination. I'm very cognizant of the time. This is the last formal presentation, but after I finish up, I will turn it over to Representative Dave Rogers to discuss new developments at the State House. The EEOC guidelines, or the guidance, is a 49-page document here. It's pretty thick, pretty dense, but not too bad to get through. So I'm just going to try and highlight some of the more tricky issues that arise relating to national origin discrimination. First is the basics, which is the Equal Employment Opportunity Commission is the federal agency responsible for the administration and enforcement of Title VII. Title VII, the federal Civil Rights Act relating to employment. It applies to, in general, all employers with at least 15 employees. There are certain very, very narrow exceptions to that, but so in general, Title VII will apply. The EEOC in November issued this new guidance, which replaced an older version. I'm going to talk again about the issues that I think were worth highlighting in them. There is a caution I would like to make, which is that the EEOC guidance is non-binding. So what the EEOC is not the end-all, be-all of your issue with regards to national origin discrimination. It's not going to be dispositive of the issue, but it might be helpful, and it certainly could be persuasive to a court to rely on. And the EEOC, in fact, recognizes that and says in the guidance, it says, where the lower courts have not consistently applied the law or the EEOC's interpretation of the law differs in some reason, this guidance sets forth the EEOC's considered position and explains its analysis. So it's a nice little recognition that it might not be worth much, but at least they've thought about it and come up with what they think is the best. The other thing to note is that there was a recent Supreme Court justice who was confirmed who has expressed skepticism about giving federal agencies deference, and that could impact how the EEOC's guidance, the weight that it's accorded. I do know that in my practice, I do consult with the EEOC guidance on, for example, ADA compliance and reasonable accommodations, as well as sexual harassment from time to time. So I think most lawyers probably look at them too, and it's good to recognize that they can be very helpful and they can be persuasive, but they're never dispositive on an issue. The other caution that's important to note is that Massachusetts law, other states' laws, or municipal ordinances might be more protective of employees. So something that might be in compliance with Title VII might violate 151B or another state or local ordinance. Now, as I mentioned, a late 2016 federal agency's guidance, in particular about national origin discrimination, I know something I was thinking about when I was reading it, and maybe some of you might be thinking about, is the elephant in the room, which is the new administration and what the new administration will do with the national origin discrimination guidance. The Trump administration will have the opportunity to pack the EEOC with commissioners. Currently, so the composition of the EEOC is there's 5 commissioners. They're generally appointed on a bipartisan basis. There's no formal rule requiring that. And there's also a general counsel. All commissioners are appointed by the president and then need to be approved by the Senate. Currently, there's 1 out of 5 vacancies, and by next year, 2 more terms will end. So within the next probably 13 to 14 months, the new administration will have the opportunity to appoint at least 3 commissioners for a majority of the commissioners, as well as the general counsel to the EEOC. So that will that could impact whether these national origin discrimination guidances are kept or whether they're amended or modified. I also chose this tweet as a good example. I know this was done by a candidate for president, but this was also someone who is a job creator and is an executive at a very large company. And at least from my vantage point, I think showed a little bit of insensitivity to national origin with this tweet on, and it's a good teachable moment for what not to do as an executive level. I think first of all, I think most people would realize that Cinco de Mayo is a Mexican holiday, yet the inability to grasp the difference between someone who is of Mexican origin versus someone who is of Hispanic origin is troubling, as well as the grouping fast food taco bowl as part of Mexican culture. So for those of you celebrating the Chinese New Year, maybe not to take a picture of the Panda Express you're having for lunch. That would be my best legal advice. So I think that also is a good transition into what is national origin. That was one of the issues that's been identified as tricky. National origin can sometimes be synonymous with ethnicity, but it can also mean place of origin, geographic place of origin, both at a country level, at a regional level, at a geographic region within a country. So how the EEOC defines discrimination based on national origin is where it is motivated because an individual is from a certain place or has the physical, cultural, or linguistic characteristics of a particular national origin. So some of the things that they identified as setting forth these cultural or linguistic traits, so it could be based on their accent and language, the name that they might have, the style of dress they might have, those can all form the basis of national origin protection. They also note that place of origin can depend on the individual. So for example, someone who's Egyptian might identify as Middle Eastern, they might identify as Arab, they might identify as Egyptian. Someone who's from Russia might identify as Russian, they might identify as Chechnyan. It's that individual who defines themselves. Now, I think we're all pretty comfortable with what adverse employment actions are. I just wanted to highlight a few of them. The most important, I think, is the hostile work environment based on harassment. What the EEOC reports is that up to 40% of charges or complaints that are filed based on national origin relate to discrimination through the creation of a hostile work environment. A hostile work environment exists where the environment or the level of harassment is so severe or pervasive that it materially alters the terms and conditions of employment. What needs to be proven for there to be a hostile work environment is that the environment must be subjectively offensive to the employee, but it also must be objectively offensive to the reasonable person. The reasonable person standard is important because it ensures that an overly sensitive employee is not automatically protected. There needs to be some requirement that it is objectively offensive to the reasonable person. There are examples of what may constitute harassment that are listed in the guidance. Those include such things as nicknames, mocking an individual's accent, stereotyping based on national origin, offensive assumptions about the national origin, segregating individuals based on national origin. So for example, at a restaurant, if everyone in the front of the house is of one ethnic makeup and everyone in the back of the house is of another, that might be something that the EEOC finds troubling. And then also language restrictive policies, including English-only rules. I'll talk about English-only rules in a second as well. Something else that's important to remember is that what is perceived can still be actionable. So for example, an employer that feels that customers might not be comfortable with someone whose first language is not English, if that motivates a decision, it still may violate Title VII, even if it's not based on the employer's animus, but rather it's based on the perception of the customer's animus. Another example that they gave was, for example, if a company did not want to hire someone who's Middle Eastern or Arab as a bus driver because of stereotypical thinking of the customers who would go on the bus about it, they said that that would likewise be actionable. Quickly to talk about citizenship, what the EEOC says is that a citizenship requirement is discriminatory when it has the purpose or effect of discriminating on the basis of national origin. So I think a blanket restriction would probably run afoul of Title VII. That's how the EEOC has interpreted it. Also looking at some sort of adverse action towards individuals who lack a social security number may be discriminatory if it disproportionately affects individuals based on national origin. With regards to English fluency requirements, they're only permissible where it is required for the effective performance of the position. The EEOC cautions that a blanket prohibition across job duties is likely to be discriminatory just because it doesn't consider each of the nuances and the requirements of each job position. Now, with regards to an employer that makes a decision based on accents, whether there's suitability for employment based on accents, you are only allowed to do so if it interferes materially with an employee's job performance. Otherwise, an accent cannot be considered. There's also a Title VII presumption that English-only workplace policies are discriminatory. That's not new. It's been around since 1980, but I think the EEOC wanted to highlight it because of a fear that there was sort of a backslide towards that type of thinking among certain employers. Now, the EEOC, at the end of this 49-page document, they set forth what they believe are promising practices, which means the types of practices and policies that an employer might develop to better ensure compliance with these guidances. So what they consider promising practice to include is using a variety of recruitment methods, so not just through one agency, not just through advertisements on a bus, but just a variety. Also notifying the applicants through the candidacy, through the advertisement, that the employer is an equal employment opportunity employer. The use of written objective criteria for evaluating candidates, objective job-related criteria for identifying insufficient job performance, which can lead to discipline or discharge, and then very clear well-written, well-developed, and implemented uniformly policies and practices relating to harassment. It's also important to communicate to employees about those policies. Now, that serves a dual purpose. First of all, it prevents harassment, but second of all, it can also help defend a claim of harassment if it's not necessarily reported quickly. If you've repeatedly told an employee to report harassment and the employee fails to report harassment over a long period of time, that might help shield the employer from certain liability if there's an allegation that it should have taken more steps. If the employer didn't know about it and told the employee about it, that can help prevent it. So now I'm going to turn the floor over to Representative Dave Rogers, and I appreciate everyone's time and listening to me.
Well, good morning, everybody. And I think we're nearing the end of our allotted time, so I'm going to go through things, my piece of this fairly quickly. But first, I want to thank my colleague, Gary Feldman, for clarifying the nature of my relationship to the marijuana issue. So I'm the vice chair of the Marijuana Committee, and we're looking at the ballot initiative that was passed by voters. And so let me go through. I'm going to there are hundreds, even thousands of bills filed every session. And so I just want to focus on 4 that I think have some momentum and that are substantial, significant. One is actually a bill I introduced called the Pregnant Workers Fairness Act. And the serendipity, the timing is noteworthy. It passed on the floor of the House yesterday unanimously. So every Democrat, every Republican, the Senate is going to take it up. And Governor Baker was interviewed, I think, on NPR or another outlet, and he said if it passes in the form that the House passed it, he's going to sign it. So for those of you who are employment practitioners, human resources professionals, this is coming. It's going to be law. And it amends the state anti-discrimination statute, Chapter 151B, to make it unlawful to refuse to provide a reasonable accommodation for an individual due to a pregnancy or a condition related to pregnancy. It essentially tracks the same concepts as disability law. So employers must provide a reasonable accommodation. And the law actually sets forth a list of what is a reasonable accommodation. It's not an exhaustive list, so it's included but not limited to. But there are things like more frequent, longer breaks, light duty, job restructuring, temporary transfer to a less strenuous position, a private non-bathroom space for expressing breast milk, assistance with manual labor, and modified work schedules. So that's not an exhaustive list. Again, the law is clear that there could be other things. Employer is not required to provide these accommodations if it would impose an undue burden. Again, just like other disability law. And the factors there are the cost and the nature of the accommodation, the employer's overall financial resources, the size of the business, and the number, type, and location of facilities. And this applies to employers of 6 or more employees, so even quite small employers. The next item I want to talk about is paid family and medical leave. And that obviously would be a huge and substantial change in public policy affecting the workplace. And a colleague of mine, it's his #1 issue. He's pushing it hard. It has some traction. Right now, across New England, about 12% of employees already have access to some form of paid family or medical leave. 4 states have laws that do this. And in each case, the states that provide it do so by adding a benefit to a pre-existing temporary disability insurance program. We don't have such a program in Massachusetts, but this law would create it. And the proposal would create a right very similar to the Family and Medical Leave Act to recover from a serious illness or injury, to care for a seriously ill or family member, or to care for a new child. And it would create 12 weeks of paid leave. In the case of recovering from your own serious illness or injury, 26 weeks. The leave can be taken on an intermittent or reduced leave schedule with the authorization of the employer. The premiums to cover the cost of the leave would be shared equally between the employer and the employee. And there's a 7-day waiting period that would be in the law before the benefit kicks in. It's a graduated temporary disability benefit. I think the maximum is $650 a week, and to be adjusted with inflation thereafter. And the bill would actually create the Department of Family and Medical Leave within the Executive Office of Labor and Workforce Development. So it'd be a whole new agency with a director appointed by the governor. Employers can establish a program by making payments to a Family and Employment Security Trust Fund administered by the state, or by a private plan or agreement, including an insurance policy, collective bargaining agreement, or company policy, which must be approved by the department. So that is a major piece. It's brewing, and it's impossible to predict what's going to happen, but whether it passes this session or next, I think it's a concept that has some momentum here. Just two more to go through. Non-competition. I don't know how many of you followed this last time. A non-competition bill for employees made it all the way to a conference committee. So the way the legislative process works, of course, the House passes a version, the Senate passes a version, and then 3 people from each body are appointed to a conference committee to negotiate differences. And those conference committee negotiations can be contentious and difficult. I thought, well, the Democrats control the House and the Senate, how hard could it be? But it turns out each body really fights hard for its version. Last time the negotiations broke down over garden leave provisions and what some call a reformation provision, meaning if a non-compete is too broad, can a judge reform it or is it discarded entirely? And those two issues apparently in conference committee caused the legislation not to move forward. The bill that's in the House right now has a few things that I'll go through quickly. It must be in writing and inform the employee of the right to consult counsel. It must be provided by the earlier of a 2-week period prior to commencing employment or a formal written offer. That can be waived in writing, that requirement. And if you present the non-competition contract to the employee after employment is commenced, continuing employment alone is not adequate consideration. An interesting twist, it must be reviewed every 3 years. So you can't just put it on the shelf and assume that it will remain valid. Every 3 years, the employer and employee would have to review it. The scope, of course, that's always the issue in the big issue in non-competes, is a 12-month limit on the duration of non-competes, unless there is a breach of fiduciary duty by the employee or theft, in which case the duration can be up to 2 years. Geographic scope also has to be reasonable, and there's a presumption in the law that if it covers the area where the employee operated, it's presumptively geographically reasonable. And then there's some carve-outs. I won't go through them all, but one example is if you're terminated without cause, the non-compete is invalid. So the concept there, of course, is if the employee didn't violate any company policies, terminated without cause, you can't tie them up in a non-compete. And then the final item I want to discuss is the minimum wage. And you may have heard this in the press, there's a so-called fight for 15 going on right now. We have a minimum wage right now of $11 an hour, and there is a coalition of labor groups and community groups, religious groups, all fighting for a piece of legislation that's pending now to gradually move up the minimum wage to $15 an hour by the year 2021. Interestingly, it would also take the tipped minimum wage. Obviously, you go to a restaurant, waiters, servers make less than the minimum wage and make it up the difference in tips. This would gradually raise the tipped minimum wage up to the regular minimum wage. It estimates, estimate is it would impact about 29% of the state's workforce, roughly 950,000 workers, 57% of whom work full-time. And of course, what labor market economists would tell you is if the minimum wage goes up for employees at the lower end of your wage scale, it's going to put pressure on wages across the board. So I think for those of you, again, in human resources, in management, or employment lawyers, it's something to be aware of, that this is a public policy debate happening in our state right now. And I primarily practice in the area of corporate law, mergers and acquisitions, licensing, but I also do some employment law incidental to that. And I'm happy to be a resource to any client of the firm as to what's going on Beacon Hill. If there's either in the employment law area or otherwise, if you just want to know, hey, there's a bill pending, what do you think? Does it have momentum? That's certainly the kind of question I can answer. So thanks a lot.
Does anybody have any questions about any of the topics that we talked about?
Okay, so the question is in conducting the survey that we talked about to provide a defense in terms of auditing, surveying your pay practices, or perhaps even compliance under the law once the law becomes effective. Since how do you identify an employee who doesn't identify with a particular gender for analysis of comparing male versus female? So I don't have an answer for you at this point, Patty. We're hoping that the Attorney General, either in their regulations or their guidance, will shed some insight onto that. That's a very good question, and hadn't even quite considered that at this point. Anything else? We'll be here if anyone wants to chat, catch up with any one of us, but we don't want to hold the rest of you up who've got your day jobs to get to. So thank you all for coming and attending.